Sovereign Citizens, The Law of Balance and Reclamation, A Study in Equity, Authority, and Commercial Redemption. Preface. Every civilization eventually writes its conscience into law, and then forgets to read it. What began as a noble attempt to organize fairness became a labyrinth of codes, statutes, and administrative presumptions. Yet behind every rule lies an echo of its creator's intent: to preserve balance. This report explores the structural and symbolic relationship between commerce, jurisdiction, and the individual. It examines how law, when misunderstood, can enslave through consent, and how, when understood, it can liberate through precision. It is both a scholarly inquiry and a field manual for reclaiming one's standing in the administrative arena without resorting to rebellion. So what does that actually mean? It means this is not a war manual, it's a reconciliation manual. Footnote. The preface establishes the thematic purpose of the work, identifying law as both a moral and administrative construct capable of either bondage or balance. 1. Scope and Method. This report does not seek to dismantle the legal system but to decode it. It interprets the evolution of jurisdictional power, from feudal compacts to commercial contracts, through a framework of equity, trust law, and modern administrative practice. It draws from historical precedents, legal maxims, and symbolic language embedded in foundational documents such as the Great Seal, the Uniform Commercial Code, and trust indentures. The method is interdisciplinary, combining jurisprudence, finance, and metaphysics. The humor is intentional. The subject matter demands it. Without levity, law becomes religion, and without structure, freedom becomes noise. Footnote. The methodology merges legal analysis, economic history, and symbolic interpretation to establish an integrated understanding of authority and remedy. 2. Purpose of the work. The intent is simple: to restore comprehension where confusion has become policy. Lawful remedy belongs not to the powerful, but to the informed. The reader is invited to engage the text not as dogma, but as dialogue, between the legal person and the living being, the fiction and the fact. So what does that actually mean? It means you can't outsmart the system until you realize you're part of its script. Footnote. The purpose section emphasizes comprehension and administrative empowerment rather than rejection of legal structures. 3. Acknowledgement of structure. This document follows the academic formality of a law school dissertation while preserving conversational clarity. Each section is deliberately capped at 2,000 characters to maintain voice cadence for text-to-speech continuity. Subsections follow a teach-trust-suggest model, emphasizing logical progression and narrative synthesis. Footnote. The report's structure balances scholarly rigor with accessible rhythm, suitable for both oral delivery and academic review. 4. Limitations and jurisdictional disclaimer. This work is educational in nature. It is not legal advice, nor does it assert authority beyond academic inquiry. Jurisdiction belongs to the reader, not to the author. The remedy discussed within is conceptual, not procedural. The true court is the conscience. So what does that actually mean? It means if you take this to trial, bring wisdom, not this report. Footnote. The disclaimer delineates academic purpose, reinforcing educational jurisdiction and protecting interpretive neutrality. 5. Dedication. To every man and woman who has ever asked, who gave them the right? And then had the courage to read the fine print. Footnote. The dedication honors inquiry and intellectual courage, the twin virtues of lawful reform.